Welcome to Moving Forward Together, Family and Immigration Law Podcast.
Welcome back to Moving Forward Together, Family and Immigration Law Podcast. I'm Lisa Mosby, your host, and today we are here with attorney Damian Crooks of Zuma Law. Damian is a founding member of the firm and has represented thousands of clients in family-based immigration, humanitarian relief, and deportation defense matters since 2011. Today, we're talking about immigration protections that are available to victims of crime. Damian will walk you through U visas, VAWA petitions, and T visas. Who may qualify for them, how these forms of relief can help families find safety and stability. We have a long list, Damian. Welcome. Are you ready to get started?
I'm ready to go.
You know, we are talking about the protections today. Can you begin by explaining the purpose behind a U visa, a VAWA petition, and a T visa?
Sure. So generally U visas and T visas are clumped together in the fact that they are visas available for certain victims of crime to help them move forward and cooperate with law enforcement. Oftentimes, individuals that might have legal status in the country are worried that if they go to law enforcement and try to cooperate on a case with a victim, they might have issues because of their legal status. A U visa is directly for certain victims of different criminal activity, which we'll talk about later. And T visas are really for trafficking victims, people who have been trafficked into the United States. Where a VAWA self-petition is really for domestic violence victims who might be dependent on their abuser to gain legal status. So the VAWA system allows an individual to file for themselves instead of having to depend upon their abusive partner and move forward with their immigration status.
Let's start with the U visas first. What types of crimes can make someone eligible, and what does a person generally need to show in order to qualify for that?
So I'll kind of reverse. I'll start with what they need to show, and I'll kind of talk about some of the crimes. But generally for a U visa, an individual has to prove 5 factors. First, they have to prove that they're a victim of a qualifying crime. That crime must, secondly, occur in the United States. Third, they must be helpful in the investigation or prosecution of the crimes committed. Either a judge, a law enforcement agency, or prosecutor has to sign a document stating that they were helpful, and they must have suffered substantial mental or physical harm because of qualifying criminal activity. Under the U visa statutes, there's 28 different qualifying crimes, but the most common we generally work with are individuals that are victims of domestic violence, individuals that are victims of sexual assault, or felonious assault. A felonious assault would be, if someone was threatened with a weapon or they were extremely battered and harmed and hospitalized.
And one of the requirements that we often hear about is cooperation with law enforcement. What does cooperation actually mean in practice, and how is that documented?
Yeah, generally for a U visa, the legal requirement is you're helpful or likely to be helpful. But generally, whether or not they can deem you as cooperating is really subjective on the agency you're asking to sign a document. There's a document called a 918 Supplement B that generally has to be signed by either the police chief of a certain agency, a prosecutor, or a judge, indicating that you have been helpful. And that can be really subjective on who is signing it. We see sometimes police agencies will be willing to sign just if you call the police, while other agencies might say, we're not going to sign this unless you went to trial and were a witness in a hearing. So it's really subjective on that individual department.
And turning to the VAWA petitions, many people are surprised to learn that this relief can apply to both women and men. Who is eligible to file under VAWA, and how does it protect someone who has experienced abuse by a U.S. citizen or maybe a permanent resident, spouse, or parent?
Sure. So a VAWA self-petition is really where an individual can take the position of their abusive partner and self-petition for themselves. The general requirements of VAWA are you must be in a qualifying relationship, which means your abuser must be a resident or citizen. You must be in a qualifying relationship, meaning that individual must be your spouse, parent, or child. You must have had joint residence with that person at some point. That during the relationship, you are subject to battery or extreme cruelty, and you're a person of good moral character. And a VAWA self-petition itself, if it's approved, would lead to a work authorization and what's called deferred action. But it also can often accompanied with a green card application or a 485, where a person might be able to become a resident through a VAWA self-petition.
And I believe VAWA is an acronym for something. What does that stand for?
It stands for the Violence Against Women Act. or it's part of the Violence Against Women Act, which is a larger piece of legislation.
And I think that's where some of the confusion comes in, because I said it can be used for women and men. It all falls under that same acronym, under that same act. Is that correct?
Correct. Both men and women can file under the Violence Against Women Act.
So T visas, they're designed for victims of trafficking. How is trafficking defined under immigration law, and how is that different from other types of crimes?
Yeah, so generally a T visa is designed for victims of severe forms of trafficking, which generally relates to sex trafficking or labor trafficking that was on part of force, fraud, or coercion. So trafficking, the T visa is different, and it's not just any a general crime that you cooperate with law enforcement. It's more designed for direct victims of trafficking, human trafficking.
And for someone who may qualify for one of these options, what kinds of evidence tend to carry the most weight when preparing an application?
Yeah, generally the primary piece of evidence in any of these applications is the person's self-affidavit. Basically, writing out what had happened, how they cooperated with the police, if it's a U or T visa, how they've been harmed because of the qualifying crimes. For a VAWA, how the relationship progressed, how did it lead to abuse, why does this person want to stay here, what are the discretionary factors, as well as secondary evidence proving that what you were saying is truthful and it's not fraudulent. For example, if you're a victim of a crime, police reports, witness statements from other individuals. Sometimes to document harm, you might have a therapist letter saying that you went to therapy because of what happened. And statements from other individuals that might have witnessed things.
So processing time for these cases can be long. What should families understand about the happenings while the case is pending, including work authorization?
Sure. So all three of these forms of relief do unfortunately take some time. The U visas are generally the longest in processing time. The reason why that is that U visas and T visas are both capped at 10,000 per year, which means they can only issue 10,000 visas in either of those categories every year. The U visas themselves are backlogged over 10 years at this point. However, they will look at the case and they would approve it, but for the cap, they will generally give an individual deferred action status and work authorization. Right now, what we're experiencing is about a year right now with work permits through U visa. T visas aren't as bad. They are kept at 10,000 per year, but because there's less individuals that are coming forward and filing T visas, those applications generally we're looking at about 3 years right now, and they too can get a work permit while they are waiting if the case is conditionally approved. For VAWA self petitions, they're not subject to a backlog, but processing times have really slowed down under the current administration due to concerns about fraudulent filings and more vetting. On average, if a person, let's say, was abused by a U.S. citizen spouse, we're looking at about 2 to 3 years for a VAWA self petition. Once a VAWA is approved, you can get a work permit, but oftentimes a VAWA self-petition will be accompanied by a green card application, which will allow you work authorization while you're waiting for that to get approved.
And then, Damian, can you actually share an example of a situation where someone believed that they had no options, but after reviewing the facts more closely, there was a form of protection that was available to help them move forward?
Well, I'll give you a couple common examples. Oftentimes, individuals don't think about U visas because the crime might have occurred a very long time ago. But with U visas, there is no statute of limitations, meaning that an individual might have been a victim of crime in 1990s and now are moving forward. As long as they cooperated within the time period of the statute of limitations, they can still request that certification and move forward. We also see a lot of people that might be indirect victims that also qualify for U visas. An indirect victim might be an individual who their children, they're under the age of 15, might have been a victim of a crime. And they cooperated because their child was unable to because they were due to their age and lack of capacity, or they might have a spouse who might have been incapacitated because of the crime victimization, and they move forward and cooperate and are eligible for a U visa. So we see those two very common that people aren't aware of.
And for someone listening who may be afraid to come forward because of their immigration status, what is important for them to understand about seeking help and speaking with an attorney before making any decisions?
Yeah, I think the biggest thing when you meet with an attorney is we have attorney-client confidentiality. And that is if you meet with an attorney from our office, they're not going to share your information with anyone. And in fact, we can't. We could get in big trouble for doing so. So you could always come in and do an initial consultation and assessment to see if you are eligible. Also, petitions for U visa, VAWA self-petitions, and T visas are under the law, sealed. So unless you are telling individuals you are filing this, no one will really know that you have filed these forms of protection.
And do you have any final thoughts for folks who might be stressing over this?
Yeah, I say that if you think you might be eligible, you can always come in for a consultation. Everything is completely confidential, and we're always truthful and honest with individuals what they're eligible for. If you don't qualify, we'll tell you don't qualify. If you do qualify, we can tell you what the likelihood of success is, processing times, and the like.
Damian, thank you so much for your insights today.
Thank you.
Folks, that's a wrap for today's episode of Moving Forward Together, Family and Immigration Law Podcast. To learn more about Damian and the immigration services he provides at Zuma Law, visit zumalegal.com. Thanks for listening, and don't forget to like, subscribe to the show, and leave a review if you found this episode helpful. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.